Hello, distinction students. Welcome to our civic education online class. This video is an introduction to major international human rights instrument. Okay, at the end of this lesson, you should be able to define the charter-based human rights instrument, abbreviated as, or rather, seen as the Universal Declaration of Human Rights, as well as describe the background to the Charter-Based Human Rights Instrument, the UDHR, and describe the International Bill of Rights. Then discuss the mechanisms that are used by the United Nations in monitoring and supervising the implementation of the Charter-Based Human Rights Instrument. Okay. Then should be able to provide a summary of the provisions that are contained in the UDHR and define treaty-based international human rights instrument. Then the background to each of the major treaty-based international human rights instruments should also be provided. So those are some of the things that you should be able to do after this lesson. Okay, so remember that when you joined the civic education online lessons, there was a topic we discussed, okay, a topic that we looked at, and it was talked about human rights in general. It gave the definition, the characteristics, as well as the sources in the categories of human rights. So now this topic will now examine the major international human rights instruments, okay? It will examine the major human rights instruments, right? So, to begin with, we're going to provide we are going to first of all look into the background information, okay? The background information. How did this United Nations Universal Declaration of Human Rights come about, okay? So, to begin with, the United Nations Declaration of Human Rights, the UNDHR, is derived from the United Nations Charter of the United Nations Organization, okay? It arose because of the gross violations of human rights that took place during the Second World War, especially by Nazi Germany, okay, against the Jews. So the Nazi Germany Nazi Germany carried out a systematic violation of the Jewish people's rights, okay? They were locked up in labor concentration camps where they worked for no pay and little food, okay? There were also camps where the Jews were gassed to their death. I'm sure most of us have watched Sobibo. That is a clear description of this Nazi Germany human rights violation. Okay, so now about 6 million Jews were killed during the war. Okay, then after the end of the war and the discovery of the atrocities that had gone on in Germany, the Charter of the United Nations recognized that there was need, okay, for an international instrument that should guard against such atrocities, okay, as the Holocaust, which was the name given to the killing of the Jews in the Second World War. So now this charter, okay, the United Nations Charter, actually began with a preamble which states, "We, the people of the United Nations, determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind." Okay? Reaffirm faith in fundamental human rights, in the dignity and worth of human person, in the equal rights of men and women, and of nations large and small. Now, from the preamble, the United Nations set itself a task of coming up with an international Bill of Rights, okay? the plan was to compose a Declaration of Human Rights, an agreement that would impose legal responsibilities on the states parties, which are countries that sign the charter. Okay, now the countries would also agree to the mechanisms of supervision by the United Nations. The result of this was the Universal Declaration of Human Rights, commonly referred to as the UDHR. Okay? Now, the Universal Declaration was adopted by the United Nations on 10th of December 1948 in Geneva. The 10th of December has from then on been observed as Human Rights Day. Okay? So, the declaration contains about 30 articles, which are a list of basic rights every human being is born with. Then, the UDHR is an internationally recognized and agreed upon instrument, through which individuals, individuals, get to through which individuals and governments can work to deliver basic rights. Okay? Now, the preamble outlines the declaration's values and beliefs, which assert justice, peace, and freedom are linked directly to respect for human rights. And aside from that, it also talks about human rights growing out of the dignity of each person. Then again, it also talks about the freedom from fear and from want can only be achieved in conditions where all rights are respected. Then that all people have a duty to promote and protect the rights of others, as well as all states are compelled to respect and promote human rights. Now, the UDHR states that all human beings, whatever race, color, nationality, sex, political, or other beliefs, however much money one may have or property, they are all entitled to the same human rights. So there is no distinction or whatsoever. Okay. Now, this UDHR has 30 articles. Okay, and these articles are divided into two themes. The first theme is the civil and political rights. Then the second one is the economic, social, and cultural rights. Okay. Now, let me just give a brief summary of the United Declaration on Human Rights articles. Okay. We have over 30 articles, and I'm just going to briefly discuss these articles, 1 to 30. So the first article is talks about being born in freedom, equality and dignity. The second, having the right not to be discriminated against on any basis, The third has the right to life and to live in freedom and safety. The fourth has the right to liberty or freedom. The fifth has the right to security of person. No one should be tortured or should suffer from cruel and inhuman treatment. Aside from that, has the right to recognition before the law. The seventh one has the rights to equality before the law and equal protection. The eighth has the right to effective remedy. The ninth has the right not to be subjected to arbitrary arrest or detention. The 10th has the right to full and fair hearing, before an impartial or independent tribunal. Then the 11th one has the right to be presumed innocent until proven guilty. The 12th one has the right to privacy. Number 13 has the right to freedom of movement. Number 14 has the right to asylum. Number 15 has the right to nationality. Number 16 has the right to marry. Number 17 has the right to own property. Number 18 has the right to freedom of thought, conscience, and religion. Number 19 has the right to freedom of opinion and expression. Number 20 has the right to freedom and assembly. freedom of assembly and association. Number 21 has the right to take part in government, access public services, as well as the right to vote. Number 22 has the right to social security. Number 23 has the right to work. Number 24 has the right to rest and leisure. Number 25 has the right to an adequate standard of living. Number 26 has the right to education. Number 27 has the right to freely participate in the cultural life of the community. Number 28 is entitled to a social and international order to realize the rights and freedoms. Number 29 has duties to the community, and above all, nobody can interpret this declaration in any way that can endanger any of the rights and freedoms of others. Okay? So, however, the Universal Declaration of Human Rights is not a binding document. It is just a declaration, and any state that signs up for it is agreeable with the contents, okay, in the declaration, but does not commit itself to being bound to implement the provisions in it, okay? So it is just, it is not a binding document, okay? So whichever state agrees to it, signs up, or rather agrees to the contents, but does not commit itself to be bound to implement the provisions in it. Okay, so now we go straight to the supervisory mechanisms for the Universal Declaration of Human Rights. Okay, so when we talk about the supervisory mechanisms for the Universal Declaration of Human Rights, we are talking about the United Nations setting in place, or rather putting in place, procedures by which it would monitor how the states, parties, nations that sign the Universal Declaration on Human Rights, are they implementing the provisions that are contained in this document or not? So that is how come we have the monitoring mechanisms under the UDHR, okay, which are also called charter-based mechanisms, okay? Why? Because they are used to supervise a charter, and the UDHR is what? Is a charter, not a treaty, okay? So it is based on a treaty. So it is not based on a treaty, and is therefore not legally binding, all right? So while a charter has no binding legal effect, okay? While a charter has no binding legal effect on states, it is a general agreement on the part of the international community, okay? And it has a strong and moral influence in the way states conduct international relations, all right? So now let's take a look at some of these charter-based monitoring mechanisms. So we have two. We have the first one, which is the 1503 procedure. Now this one was adopted by the Economic and Social Council, the ECOSOC, the ECOSOC, in 1970. It is called the 1503 procedure because it was the Council's resolution number 1503, which authorized the formation of a sub-commission on discrimination and protection of minorities to consider all communications, okay? Communications in human rights language mean a complaint received by the United Nations on consistent pattern of gross and reliably attested violations of human rights and fundamental freedoms, right? The Commission has 53 members at any one given time, all right? And it sits every year in Geneva for 6 weeks, okay, March to April. The members on the committee, right, represent states Now, apart from the 53 members, we have also other countries that observe that attend these meetings as observer states, okay? But only the 53 members vote. So the 1503 procedure is sometimes referred to as the 1503 confidential procedure because the discussions are confidential, okay? They are confidential. The procedure actually receives communication from individuals or non-governmental organizations. Then the other one is the 1235 procedure, the 1235 procedure. Now, this one was a resolution that was adopted by the ECOSOC in 1967, okay? It approved the Commission on Human Rights Decisions to consider annually questions of the violation of human rights and fundamental freedoms, including policies of racial discrimination and segregation and of apartheid in countries, okay, in all countries, with particular reference to colonial and dependent countries and territories. So, this procedure is public and can be initiated by a member of state of the declaration, okay, and can also be initiated by a group of states as well as the sub-commission, okay. Now, though this procedure, through this procedure, the Commission on Human Rights may actually investigate particular countries, okay, or particular issues. The issues may be country-based, for instance, the AD Hoc Working Group on the situation of human rights in Chile, or the thematic studies like religious intolerance and discrimination, right? Both procedures deal with the gross and systematic human rights violations affecting a large number of people and for a long period, okay? So these procedures that are charter-based do not concern themselves with individual cases, all right? Therefore, both procedures do not deal with individuals. They deal with the states that have that signed these treaties. So when an individual goes to this procedure to file complaints about human rights violation, they cannot deal with that. They only deal with the states, the organizations, okay, that go there with communications. And we have said communication in human rights language means taking a complaint, okay, about human rights violation, okay. So now let's quickly take a look at the treaty-based human rights instruments, okay? Since we have looked at the charter-based instrument, the UDHR, okay? Now, these treaty-based human rights instruments are also called covenants or conventions, okay? Whether the instrument is called a treaty or a covenant or a convention, it does not matter, okay? Since they all mean the same. Now, the most important thing to remember is that a treaty-based instrument is legally binding to the state, okay? That is a party to it. Now, this means that a state party is bound to not only translate the provisions into domestic laws, but also to implement the provisions of the treaty. All right. Now, these treaties are legally binding on the states that are party to them, okay? Being a party to a treaty means that a country has either ratified or ascended to the treaty. Now, what does it mean to ratify? When you ratify, to ratify is when a state agrees to be bound by a treaty that it has already signed, okay? It does this by writing a memo called an instrument of ratification and depositing it with the United Nations Secretary General. Now, remember that to ratify a treaty, the states must have first agreed to it, okay? So to assent to a treaty is when a state agrees to be bound by by the treaty without first having signed it. Okay, so to assent to a treaty, the state deposits an instrument of accession with the Secretary General of the United Nations. Okay, now accession has the same legal effects as what? As ratification, except that it comes after a state party has signed a treaty. Okay, now when a state signs a treaty, it is an indication that it intends to take steps to be bound by the what? By the treaty at a later date. All right, now although a treaty is legally binding, states effect the treaties depending on the type of legal systems they follow. So international law classifies countries or other states into monist and dualist. Now, what do we mean by monist countries, dualist countries? When we talk about monist countries, these are countries that regard domestic law and international law as one and the same. Okay, so they give emphasis to international law. Now, what does this mean? This means that when such a country ratifies or assents to a covenant, okay, the articles that are contained in such a covenant automatically become part of the law of the what? Of the country, and are justable. Okay, when a right is justable, it means that the government can be sued in a court of law if it is not providing the right to what? To its citizens. For instance, Netherlands, Namibia, and most francophone countries. Okay, these are monist countries. Then we have the dualist countries. Now, these are countries where international law is not directly applicable in what? In domestic law, and can only be made part of the domestic law by an act of what? Parliament. Okay, we have an example that happens in most Commonwealth countries, and Zambia can be a very perfect example. When we come to Zambia, okay, Parliament should first pass a bill on the provisions of the treaty before it can become part of the country's what? Laws. So that is the difference between the monist and the dualist countries. Okay, for the dualist countries, the international law is not directly applicable to domestic laws unless this law is actually made part of the what? Of the domestic law by an act of what? Parliament. Then for the monist countries, these ones they regard the domestic law and the international law as one. Okay. So, having discussed or rather talked about the treaty-based human rights, let's now quickly go to the International Covenants of 1966. First of all, let me just give a brief background, okay, into the International Covenants of 1966. Now, from the UDHR, okay, a large number of human rights instruments, right, they were started. Now, together, these make up the international law of human rights, okay, as already stated. So, the UDHR is not a treaty, therefore, it is not legally binding at international law. Now, what does that mean? It means that a country is not obliged by law to apply the UDHR in its domestic laws, okay? The declaration is just a resolution, a determination by the United Nations members to carry out the articles that are contained in it. So, because the UDHR is not legally binding, it was decided to translate parts of it into treaties, okay, which would be legally binding. Now, these treaties elaborate on and expand on the declaration. So, the original idea was to draw up one treaty that would elaborate on and make the rights and freedoms proclaimed in the UDHR legally binding in countries, okay, that would be party to it. Now, the General Assembly of the United Nations decided to frame two treaties, one on the civil and political rights and the other one on economic, social, and cultural rights for a number of reasons, okay? And these reasons where the two sets of rights are different, okay, as most of the civil and political rights can be enforced immediately, okay, because they require the government not to interfere with the rights and freedoms of an individual. Then the civil and political rights cost less than economic, social, and cultural rights, which need a huge outlay of resources and are therefore dependent on a country's economic ability to do what? To implement. Then the other reason is that the civil and political rights are adjustable in Zambia, which means that they are enforceable in courts of law, whereas economic, social, and cultural rights are not. For instance, if someone's liberty is taken away, the victim can sue for wrongful imprisonment. If one has no job and the victim cannot sue the government for not providing a job. Then the other reason was whereas the civil and political rights basically compel the government not to interfere with someone's freedom, economic and social and cultural rights, necessitate the government to take concrete and progressive action to enable individuals to achieve the full realization of of the rights. Then the other reason is the communist countries led by the former United Soviet Socialist Republic, but commonly called Russia, considered economic, social, and cultural rights more important than the civil and political rights, whereas the capitalist countries led by United States and America considered civil and political rights more important than economic, social, and cultural rights. Now, for all these reasons that I have just mentioned, okay, two covenants were drafted and adopted Now, in adopting the two covenants, it was decided that many articles, as much as possible, should be made similar. So now let's take a look at some of these similarities that came with these articles. So to begin with, we are going to bring out the similarities between the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. We are going to begin with the preamble, okay? So under the International Covenant on the Civil and Political Rights, okay, the preamble begins by realizing that the individual having duties to other individuals, okay, and to the community to which he belongs, okay, is under a responsibility to strive for the promotion and observance of the rights that are recognized in the present. Then when we go to the International Covenant on Economic, Social, and Cultural Rights, the preamble begins by realizing that the individual having duties to other individuals, okay, to the community which he or she belongs, is under a responsibility to strive for the promotion and observance of the rights recognized in the present. So both preambles were made as similar as possible. Now we go to the first part of Article 1, okay, on the Covenant of the Civil and Political Rights. It talks about all people having the right of self-determination, okay, to freely determine their political status and freely pursue their economic and cultural developments, okay. Then when we go to the International Covenant on Economic, Social, and Cultural Rights, it also talks about the same. Then when we go to Part 1, Article 3, in no case may a people be deprived of its own means of substance. It is also the same with the economic, social, and cultural rights. Then Part 2, Article 5, nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or to perform any act aimed at the destruction of any of the rights or freedoms that are recognized herein or at their limitation to a greater extent than is provided for in the present covenant. So it is also the same when we go to the International Covenant on Economic, Social, and cultural rights. Then Article 46 to 53 is the same as Article 24 to 31 on the side of the economic, social, and cultural rights. Then Article 22, the right to join and form trade unions, okay? That is on the International Covenant on Civil and Political Rights. Then when we go to Article 8, it is also the same. Then Article 23 talks about the right to protection of family. That is under the Covenant on Civil and Political Rights. Then Article 10 is also similar. It also talks about the right to the protection of the family under the International Covenant on Economic, Social, and Cultural Rights. So those are some of the similarities that were brought about, or rather that were merged, okay, between the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, because in one way or the other, they were similar, okay. Then we now talk about the convention or treaty-based monitoring mechanisms, okay. The convention on the treaty-based monitoring mechanisms, okay. So under these treaty-based monitoring mechanisms, like charter-based, these are ways in which the United Nations monitors the implementation of the provisions that are in the treaties. So these monitoring mechanisms were established by treaties. So each international instrument has a committee that supervises implementation. So the United Nations system currently has 7 treaty committees, okay? Has 7 treaty committees. We have the Human Rights Committee, which monitors the implementation of the International Covenant on Civil and Political Rights that was created in 1969. Then the other one is the Committee on Economic, Social, and Cultural Rights that was created in 1987. The other one is the Committee Against Torture, which is abbreviated as CAT, or rather CAT, that was created in 1987. The other one is the Committee on the Elimination of Discrimination Against Women, CEDAW, created in 1982. The other one is the Committee on the Rights of the Child, CRC, created in 1990. The other one is the Committee on Elimination of Racial Discrimination, ICERD, that was created in 1969. The last one is the Committee on Migrant Workers, CMW, created in 2004. Okay, so we have other treaty-based supervisory mechanisms in these, and one of them is the state party reports. Now, under this one, each state belonging to a treaty is required to submit the committee that supervises the treaty at certain periodic times. The reports actually outline the measures that are taken by the country to effect the rights recognizing or granted in the, or rather guaranteed in the particular treaty, okay? These periods range from 3 to 5 years, and the reports are meant to review the implementation, monitor implementation, provide basis for policy formulation, give the public an opportunity to examine the country's implementation of the treaty, evaluate the country's implementation of the treaty, acknowledge problems the country is facing in an implementation of the treaty, okay, as well as act as an information exchange of the state parties' implementation of the instrument. Then aside from that, we have the interstate complaints procedure, which allows a state party to complain when another state party has violated or is not fulfilling its obligations under a particular treaty. So both complaining state and the state complained against must be parties to the treaty consent, and both should have agreed that the committee in charge of the implementation of the treaty is acceptable to them to receive and consider such complaints. Okay. Aside from that, we have the individual petitions procedure. This one permits individuals to bring complaints to the committee on the violations of human rights. The individual must exhaust local and domestic complaints, okay, which must be anonymous, rude, and must be about violations of rights contained in the particular convention. Then the last one is the inquiry procedure. This one is instituted by the supervising committee upon receiving reliable information alleging serious violations of rights. Okay, the committee may even visit the countries suspected of such violations. A state may actually choose not to accept the inquiry procedure by making a declaration at the time of ratification or accession that it does not recognize the competence of the committee to take action against it. All right. So now, the International Covenant on Economic, Social, and Cultural Rights from 1966. Now, this one begins with a preamble that gives an outline for the explanation of the rights in the covenant. It talks about what is contained in the UDHR and says the rights in the covenant are based on the inherent dignity of the human person. Okay, so the preamble also emphasizes the invisibility and independence of all human rights by stating that the ideal of free human beings enjoying freedom from fear and want can only be achieved if conditions are created in which everyone may enjoy his economic, social, cultural rights, as well as his civil and political rights. So now let's just briefly make a summary of the provisions in the International Covenant on Economic, Social, and Cultural Rights. What are some of the rights that this covenant contains? It contains the right to work, right to just and favorable conditions of work, including fair wages, equal pay for equal work, and holidays with pay, right to inform and join trade unions, including the right to strike, right to social security, protection of the family, including special assistance for mothers and children, right to an adequate standard of living, including adequate food, clothing, and housing, continuous improvement of living conditions, right to the highest attainable standard of physical and mental health, right to education, primary education being compulsory and free for all, and secondary higher education generally accessible to all. Permits the progressive implementation of Article 13, the right to education, right to participate in cultural life and enjoy the benefits of scientific progress. So there are at least two mechanisms that are used, which are the Committee on Economic, Social, and Cultural Rights, as well as state party reporting. Then let's also look at the brief summary of the provisions in the International Covenant on Civil and Political Rights. What are some of these rights that are contained in this convention? We have the right to life, freedom from torture and inhuman treatment, freedom from slavery and forced labor, right to liberty and security, right of detained persons to be treated with humanity, freedom from imprisonment for debt, freedom of movement and choice of residence, freedom of aliens from arbitrary expulsion, right to a fair trial, protection against retroactivity of the criminal law, right to recognition as a person before the law, right to privacy, freedom of thought or conscience and religion, freedom of opinion and of expression, prohibition of propaganda for war and of incitement to national, racial or religious hatred, right to assembly, freedom of association, right to marry and find a family, rights of the child, political rights, equality before the law, rights to minorities. So those are that is a summary of the provisions in the International Covenant on Civil and Political Rights that was created in 1966. So this first part of the lesson has discussed the declaration as well as the mechanisms and the conventions. Okay, so now look out for the second part of the lesson that will continue the discussion. Please go through the video as many times as possible to help you understand better.